all forensic science is junk. I certainly don't believe it. I actually think it's pretty valuable. I think our society is way better off for having forensic science than not. I just think that in its current form, we don't have the right information, jurors don't have the right information to give it the right amount of weight. So I'm not trying to slander any particular forensic science. I want them all tested. That's what I want.
Thank you for everything you said. Question: if this is so questionable from what you say in this adversarial system that you have, what is the value that the jurors to know that they don't, CMS or whatever? CSI, they don't show all of this. They just show the technology and how highly rated it is, and they act like it's done on every case. So the drill system boxes, here's the doctor, so-and-so, and that kind of stuff. They're not going to sit down and read on every things like you just all of a sudden use.
Right. Well, okay, they're not going to hear this lecture, but I think we can make some head. They're going to come in with very strong prior beliefs that this is great stuff. So you're right about that, and we can only disabuse them of that to some extent. What I want is to not reinforce it. And it's going to get reinforced. Right now with experts saying I'm 100% certainty there's no error rate, we've never made a mistake, and I'm not aware of anyone who's ever made a mistake on the proficiency test, which is very common testimony. That all reinforces the CSI view. But imagine the judge, I think, is a very credible figure in the courtroom. I think the judge is such an authority figure. If the judge provides instructions, maybe the psychologist will disagree with me. I actually think judicial instructions can make a difference if they say, you've heard from the expert, or you will hear from the expert. It's usually better to give the instructions first, by the way. You will hear from the expert. What you should know is that they are not offering you scientific conclusions. They're offering you their opinions based on experience. They have not done the necessary scientific studies to validate what they're saying. That would be terrific. That'd be great, because they're still going to hear it, but they're going to know that it's, at least I think they might think, wow, I thought this was really scientific, the CSI said so. The judge is telling me otherwise, and if on cross-examination, they have to admit, I'm really not sure about this match. And if the defense brings in a witness who says none of this has been studied, maybe we'll make some headway. I mean, I'm not disagreeing with you entirely, but I think we can do a better job giving jurors the right impression about how diagnostic or how probative this evidence is by forcing the testing.
That one chart it showed that the scientists sometimes were not getting false statements, and the prosecution was also, and it was high on the chart.
Prosecutorial misconduct was also kind of high.
I was just wondering if the political pressure, if they put political pressure on running scientists, or if there is the pressure on them to go along with prosecution. So it could be like I'm just thinking,
Sure. Yeah, I mean, there's the nature of this adversarial system, there's a lot of pressure on the prosecutor. You know, once they decide to go, I mean, they can be scientists and try to figure it out in advance, right? But once they have decided to go for it and prosecute, now it is totally adversarial. They just want every bit of confirming evidence in and every bit of disconfirming evidence out. They are not scientific truth seekers, right? And likewise, the defense attorneys aren't truth seekers either. They just, that's our adversarial system. The theory is not a good one. The scientific theory is much better, but the theory is truth will emerge if you let the two combatants go at it from the extremes, right? I don't think it's a good theory, but that is our legal system. Where the people I think are caught in the middle of this are the forensic scientists, because they are working so closely with the one side, and they feel that connection with the one side. They're often told, we need the match, you gotta come through for me, right? They have personal relationships with the prosecutors and with the investigators. And that's one thing that this report actually recommended, is breaking them apart, making them more independent. That doesn't look like it's going to go anywhere. A lot of people think that's a dead-on-arrival suggestion, but they made a big suggestion that will try to break apart forensic scientists from the prosecutors today. I can just tell you, I don't get involved in consulting very much or testifying very much at all, but there was one case, I think I told Sherry about it when I saw her recently, where this attorney was calling me frequently, and it was a rape case, and I was on the side of the defense, and he said, and I was going to talk about errors and error rates and this sort of thing. And one day the defense attorney called me up, he said, good news, 2 of their eyewitnesses dropped out. And I said, all right. And I'm thinking, why am I saying all right? Why is this good? And it was good. It felt good to me that their case was falling apart. because I had this relationship with this lawyer, and I wanted to win, and I wanted him to win, and I liked him, and, right? So all of a sudden, these personal relationships move you away from being a scientist, move you into the domain of being an advocate. And, you know, that is an issue that our legal system.
You make it sound so easy.
Do you think, oh, is there somebody else?
No, go ahead, go ahead.
Okay. Do you think it'd be more beneficial for the accuracy of forensic evidence to be overestimated or underestimated in court?
Underestimated. I think it's better to underestimate. Well, first of all, you know, we believe in this idea it's better to, you know, let some guilty go free than to convict the innocent. So there's that weighs in favor of underestimating. But another argument that weighs in favor of underestimating is a lot of times, even if you underestimate the value, the probative value of your evidence, it's still very strong. And it still might be enough to tip people over the edge. You know, you don't have to have 1 billion to 1 random match probability. Sometimes just knowing that there's a match and only 1 in 1,000 people will match could and should be very compelling evidence. So I'm all in favor of underestimating, you know, erring on the conservative side for those 2 reasons. 1, we don't want to convict the guilty, obviously we want to err on that side, but 2, I still think the evidence could wind up being very powerful once we get the data.
Like the value of your work has been recognized and rewarded by grants and awards and so on. And I'm wondering, by the same token, are there scientific groups that recognize these problems and through awards or grants are encouraging more scientific approach to validating forensic evidence?
Yeah, that's a really nice question because I would say times are changing. The agency that I typically go to when I'm looking for grants is the National Science Foundation. And the National Science Foundation historically has had no interest in forensic science because the National Science Foundation is a very pure, scientific, theoretically based organization. They always want to hear about theory and what kind of studies you're going to do to validate or disconfirm your theory. Forensic science doesn't really have much in the way of theory. Right? It's a very applied science. So typically now it's outside the domain of the National Science Foundation and in the domain of groups that are more interested in justice, like the National Institute of Justice. But very recently, the National Science Foundation has gotten interested in forensic science. I'm not sure why, but they want to see partnerships. So that's one reason we did our conference at Northwestern last year. We brought psychologists together with forensic scientists to talk about cognitive bias in forensic science and how can we get together with forensic scientists and conduct studies that will help us improve the forensic sciences on the one hand and develop psychological theory, which the National Science Foundation wants on the other hand. So we're seeing a movement, we're seeing big dollars now, but we're seeing some interest from the major scientific organizations, and that's new.
Maybe 20, 25 years ago, there was in psychology, there was a case that I'm trying to remember what the name would be. But for a while, there were a number of articles saying that for us to be presenting data in court, we had to present also the validity of that data and that kind of support of what one was presenting. And so there was there were a number of articles published in psychology saying, well, you know, some tests are going to pass this, pass muster on this, and some tests that we use are not going to make it, and this kind of thing. Well, I'm yet to be asked when I'm in the witness chair to validate, to present any validity on any of the questionnaires I use or anything else. What happened with all of that?
Well, first of all, you live in Illinois.
Yeah.
Illinois is a Fry state. So there's 2 different standards for admitting scientific evidence. One is the Fry standard and one is the Daubert standard. The Fry standard is the old standard, and that's, we admit it if it's judged to be, if it's generally accepted in the relevant scientific community. So if you're a psychologist and you say that most psychologists do surveys of this sort, all the judge has to do to admit it is to say, you're the expert, and if most experts agree with you, in it comes. That's the Fry standard. Illinois still follows the Fry standard. The federal government and most other states actually follow the Daubert standard, which is a case in the
That's what
early
I read.
90s. And Daubert says two things. One, it says your scientific evidence has to be relevant, obviously, so not what we're talking about that one. But the other point is it must be reliable. And by reliable, what they mean is it has to constitute scientific knowledge. You have to show that the facts that you're presenting were brought in using the scientific method or scientific process for obtaining information. And that's a much tougher standard, I think, and it's a more scientific one. And so in theory, it doesn't matter what everybody thinks in the scientific community. It might matter a little bit, but that's not the determining factor. What determines it is it really good science? Are there standards? Has it been tested? Is it peer reviewed? Is it falsifiable? And the court identified a bunch of things that you can look at, so that if your science is junky or hasn't been tested, or there's no error rate for it, in theory, it shouldn't get in. So this is why some of the forensic sciences could face an uphill battle. Forensic sciences that traditionally have been under the old standard. Is it generally accepted? Of course it's generally accepted. We don't do it. This is great stuff. Now under the new standard, there are challenges. There are Daubert challenges to things even as basic as fingerprints. Because the claim is it's not science because we don't know the error rates. Most courts aren't going for that argument. That hasn't been a winning argument yet. But I think if judges toughen up a little bit and say, you've got to at least show some movement in this direction, but start testing yourself, I think it'll make a difference.
How do you spell those two standards?
Frye is F-R-Y-E. It's a case it's actually a DC Circuit case in 1923. It's only one page, really easy to read. And the other one is Daubert, D-A-U-B-E-R-T, in 1993. Daubert versus Merrill Dow Pharmaceuticals. I'm not sure I spelled Merrill Dow, M-E-R-R-E-L-L, I think, Merrill Dow Pharmaceuticals. And that's a U.S. Supreme Court case.
So what is being done or what should be done to pressure trial judges to start getting involved?
I don't know. I mean, what incentive do they have to do this? Not much. Because a lot of trial judges' attitude is, I just let it in. And all of those criticisms I hear you, defense attorney, making go to weight, not admissibility. That's the common argument that's made. Sure, you've got all these criticisms, haven't been tested on it, bring it up in front of the jury. Let them know they shouldn't pay attention to this evidence. The problem is, unless you make it an admissibility issue, the forensic science committee doesn't have incentive to change. How can we create incentive for the trial judges? I guess the appellate courts have to start taking Daubert seriously and say, we're really supposed to identify, among other things, error rates for all these techniques, and you don't have it in forensic sciences. So they have to start enforcing at that level. I don't really know how that happens. It might happen a little bit with dorky academics like me writing articles.